I remember that this was this my last year.
I think so.
So right, I'm not.
Yeah, or something.
Full of fuel.
Good morning, everyone.
Good morning.
Can everyone hear me in New York?
Yes.
All right, and we can hear you too. So first of all, thank you everyone for taking the time out to be here. We appreciate the time that everyone puts in. Welcome. Before we get started with the rest of the agenda, I did have one thing I wanted to address, and that is we have a member who, this may be your last meeting, Kathy. I don't know for sure. We're still waiting on the appointments office, but in the event it is, I didn't want to miss the opportunity to both recognize you for the great work that you've done for this commission, and thank you. You know, like everyone else here, I know that your full-time job is very demanding, and the work you do with the have done with the Lab Directors Association is very demanding, and taking the time out to serve on this commission and to do the work that you've done is greatly appreciated. So just wanted to recognize you for I guess it was actually two different stints of service, one which predated me from 2004 to 2006, and then again from 2009 to 2015. So we do have a plaque for you that indicates in recognition of your years of dedicated service and your many contributions to the New York State Commission on Forensic Science. And again, just know that we greatly appreciate your service, and thank you.
Thank you very much. Appreciate it.
Probably get extra thanks for putting up with Bill Fitzpatrick for all these years, too.
That's a much bigger one.
No, they make plaques for that. All right. I think that's all the humor we're going to have for this meeting, unfortunately. So, yes, the next item we have is review and approval of the meeting agenda. I believe the agenda has been sent out in advance. Do we have any comments? And if not, do I have a motion to approve the agenda?
So moved.
Do I have a second?
Can I just
Yes.
ask, would there be any chance we can move the NICLAC letter earlier in the agenda in case we get cut off? Or think we could maybe put it under the old business earlier on or anything?
Yeah, I intend to get to this entire agenda. We can, if people want to move things around, but my guess is everyone has something they need to get to. I personally don't have any preference when we do it, but as I said, I intend to get through the whole thing. We've got 4 hours.
Okay, I mean, could we perhaps put it after the hair talk so that we can make sure that we get to it when more members might be here? Or?
Does anyone have any objection to doing that?
No objection.
All right, and we will put it where are you saying the hair issue is?
I'm thinking perhaps after A of old business.
Okay.
Thank you, I appreciate
We'll
that.
do that.
I apologize for
No,
changing
that's
your
all
motion.
right. With that change, do we have any other comment? If not, do we have a motion to approve the agenda? All right, do we have a second? All in favor? Anyone opposed? Our next item is a review and approval of the minutes of our June 19th, 2015 commission meeting. Again, those have been sent out to all the commission members. Do we have any discussion? And if not, do I have a motion to approve those minutes?
Motion to approve.
All right, do I have a second?
Second.
All in favor? Anyone opposed? That carries. The next set of items on the agenda deal with accreditation. Brian, do you want to take us through the accreditations?
Sure. The first item is the Erie County Department of Central Police Services, and they have a continuation of accreditation letter. They had a surveillance visit. Members of the lab are available via phone if there's any questions. Okay. Next item is the New York City Police Department. They have just a note of key management change. Representatives from the NYPD lab are in New York City if anyone has any questions. Okay. Similarly, the New York City Office of Chief Medical Examiner, Department of Forensic Biology has a change in key management, and they also have another member who is their QA manager for the Forensic Biology Lab, who's now going to be the QA manager for all the labs within the OCME. So I believe members of that are in New York City, if there's any questions. Okay. The next item is the New York City Office of Chief Medical Examiner, Forensic Toxicology Laboratory. This item will be... Yes.
Brian, I just have one question of the folks at OCME. I don't know, we had another chance to bring up OCME and biology during this meeting, or this would be the only opportunity?
Under the accreditation part regarding the change in top management, there are other issues later in the agenda.
On biology?
Yes.
Okay, then I can wait.
Okay. So the next thing is the New York City Office of Chief Medical Examiner, Forensic Toxicology Laboratory. This item does require a vote. Last time the laboratory was granted an extension to September 30th of their accreditation to remediate some issues. They have provided additional documentation, which is in your binders, and you've had a chance to review. And we received a letter yesterday, which was distributed electronically to members in New York City and hard copy here to members in Albany as well, which says the continuation of accreditation through ABFT. So if there's any questions about that, I believe Mr. Dunn is in New York City as the acting director of that laboratory. Any questions before we move forward?
Mr. Dunn is informed is held up in traffic. There are other OCME personnel here if you want to speak with them.
Does anyone have any questions for the OCME talks? So at that point, I don't know.
So we need a vote on accreditation at this
Yes.
point? And this is the letter that we received last night?
Correct. Or the night before.
Okay. If there's no questions for the OCME, then I think we do need a vote with regard to their accreditation. So do I have a motion to grant
One
the...
question.
Yes, Mark.
Just before, sorry I was late on that.
No, that's all right.
It's anybody who's here from OCME who has knowledge of the nonconformity reporting form. Is there anybody here who can answer questions about that?
I can answer.
Okay, if you just identify yourself.
Meredith Rosenberg, Quality Assurance Manager for the Department of Forensic Biology and Quality Coordinator for Office of Chief Medical Examiner.
Thank you. This particular form that has been submitted, we've seen this form before. It's certainly different iteration, but more or less the same. This is the form that would be used to report a nonconformity in the lab. Am I correct? Now, my question is this. When is this form filled out in relation to the discovery of a nonconformity?
This form should be filled out
You know where he
as
is.
soon as the nonconformity is discovered, or very near that time frame.
Okay, so just to be clear.
Marvin, can I just ask you, there's a few people here looking to try and find out where you are with regard, is the form you're referring to in the material somewhere?
Yes, it's under a document called Forensic Toxicology Laboratory, Office of the Chief Medical Examiner, Non-Conforming Work Procedure. It consists of 4 pages initially, and then comes the actual reporting form, which consists of 3 pages. I can wait if you want to find it. This is under the accreditation documents for the Forensic Toxicology Laboratory. I don't see any other way to identify it by general number.
You see if you're finding it.
Not there yet.
You said about halfway.
That's it.
No, it looks like halfway, it's not that.
It's the third yellow,
It's a procedure.
third yellow page. Called Quality Assurance and Quality Control. Maybe the fourth.
Maybe five. It's 5 or 6 yellow sheets. Scott counted 8 yellow sheets.
Non-conforming work procedure?
Yep.
Yeah.
Correct.
There's a bunch right next. It's okay. This one.
Yeah.
If you go from the,
Yeah.
past 4 yellow spaces. What's that one say? Is that water? You gonna listen back to that?
She's asking about specific.
Thank you. All right, thank you, Marvin.
Have you got it?
I think we all do.
Great. May I proceed?
Please do.
Thank you. So, as you just indicated, the form should be filled out upon discovery of the nonconformity. When you say upon discovery, does that mean at the moment that something's discovered? Does it mean something was discovered and an investigation has been commenced to determine if we have a nonconformity? And at the conclusion of the investigation or during the investigation, the form would be filled out.
I'll turn it over to Ronaldo Fonseca, who's their
You just
laboratory
put
quality manager.
say your name for the record.
Ronaldo Fonseca, I'm the QA manager for the Forensic Toxicology Laboratory, Office of the Chief Medical Examiner.
Thank you.
Yes, we just standardized the non-conforming work for our laboratory, and once the non-conforming work has been tested in the laboratory, that's when we're going to start filling out this form. The person who discovers the non-conforming work becomes the principal investigator. So that's something, and it will be a good effort between the principal investigator and myself as the QA manager or any assistant director of the laboratory to complete this form.
So to be clear, the nonconformity is discovered, the form is immediately filled out, and the investigation ensues. Correct? Now, would I be correct, and you tell me if I am or I'm wrong, that a nonconformity reporting form such as the one we're talking about in these materials, it would be filled out regardless of whether the ensuing investigation shows there was a nonconformity that was found or not found?
It's going to fill out if the nonconformity has been found.
If it has been found.
Right.
So if somebody discovers a nonconformity and you fill out the form and subsequently there's an investigation and the nonconformity turns out not to be a nonconformity,
It's still going to document.
the form stays. And where does the form go?
Well, right now we have a binder with listing all of the non-conforming for each section within the laboratory. And, we're standardizing this within our laboratory because we have done this for many years. This type of forms will end up in a case file.
So,
So it was not readily accessible for the laboratory where they are.
So-
Now we're standardizing that procedure, so it will be on a binder.
so this binder, where is it kept in the laboratory? In which section?
Main office.
The main office. And it's your intention to have these nonconformities eventually, these forms, placed in the case file.
Yes.
So if a prosecutor or a judge or a defense attorney said to a court, we're seeking in discovery the nonconformities forms for this biology lab section from date X to date Y, would the attorneys or the judge say, search in the binder, or would they say, search in the case file for this particular case that's before the court?
Should be involved.
Both. Okay. Final set of questions. Would it be fair to say that as of this moment in the OCME office, that there is no rule, regulation, written or unwritten, that says if the final result of an investigation into a nonconformity, which shows a nonconformity, but does not affect the final results of the testing, that a nonconformity file form would still be made out?
There is no agency, there's no agency rule concerning nonconformity. We have root cause analysis protocol for
Right.
the agency. Each laboratory has their own way in which they handle nonconforming work. And so in the Department of Forensic Biology,
Right.
and in the Department of Forensic Toxicology, if there's a nonconforming work, a form is filled out, even if it's found that it's not, it turns out not to be something that was non-conforming work, which I have never seen. If something kicks off investigating a nonconformity, it usually is a nonconformity, so the form gets filled out.
When, may I ask, did this nonconformity form go into effect?
For forensic biology, it's been in effect for years. For forensic toxicology, it's just been standardized.
And when you say for years, that would include the DNA section of the forensic biology.
Correct.
So if, for example, again, just to clarify, if there was a nonconformity discovered in the DNA section, so for example, a contamination, all right? And upon discovery, a form would be filled out,
Correct.
and subsequently the investigation reveals that there was indeed a nonconformity, but it did not affect the final report because the final report had not yet been done.
It's still filled out.
It's still filled out,
Absolutely.
and it still would exist.
Absolutely.
And the final question of this final set of questions is, does the laboratory consider the nonconformity reporting form to be a form of Brady material under criminal law? Or is that something that you can't answer?
I couldn't answer that.
Has that issue ever been raised between yourselves in the laboratory or in the toxicology lab as to what is the status of a nonconformity reporting form, whether it fits within the Brady rule?
I do not know if it fits within, I don't know what exactly the Brady rule states to say whether it fits in or not.
Is that because you don't? I'm sorry, go ahead.
I would refer to counsel.
You would refer to counsel. Right. Okay, but in any case, this form, once there's a discovery, with absent an investigation, the form comes into existence and it's saved. And it's either kept in a binder or in the case file. And that's across the lab.
Toxicology keeps their non-conforming work in the case file as well as in a binder. Biology will keep it in a binder and electronically in a database.
In a binder. And for forensic biology, where is the binder maintained?
In my office.
And so if I were a defense attorney and I wanted these nonconformity forms, I would tell a court they're in a binder in the office of the quality assurance manager for forensic biology section.
Correct.
Thank you very much.
All right, any other questions for the, with regard to the OCME Forensic Toxicology Lab and their accreditation? If not, then do I have a motion to grant the OCME Forensic Toxicology Lab New York State accreditation for the period of time that corresponds with their just granted ABFT accreditation? I've got a motion. Do I have a second? Any discussion? All in favor?
Anyone in New York is voting?
Is anyone in New York voting on this?
Yes.
And anyone opposed? Did anyone abstain? Okay. So one abstention. Thank you.
Okay. The next item under accreditation is the New York State Police. They have some changes in top management within their laboratories. We have members of the state police here if there's any questions regarding that. Okay. Hearing none, the Onondaga County Health Department Forensic Toxicology Laboratory, at the last meeting, they were asked to provide a CV and some essentially the command of the laboratory. Both of those documents are in your binder and you've received them, and we have a representative of the lab here if there's any questions. Okay. And lastly, under accreditation is the Westchester County Department of Public Safety Crime Laboratory, another change in top management, and we have the lab director here if there's any questions regarding that. Okay.
All right, that takes care of accreditations. We're now on to number 5, old business. The first item we have under old business is an update with regard to the status of our hair evaluation effort. Brian, do you want to give us an update on where we are?
Right. Well, we have 9 transcripts that were provided in advance of the meeting in this bound document to commission members, and Commission Member Fitzpatrick also secured 2 more transcripts that were provided to commission members. In addition to that, we've had some correspondence with DOJ and the FBI, and also received some guidance documents from them, and there's some other materials regarding that in the binder. So at this point, I guess it's up for discussion.
Perhaps I can start it, Mike?
Certainly, Peter.
First of all, Brian, wanted to apologize for the way I spoke to you at the last meeting. Having looked at what I said and how it came up, I think it was inappropriate, and I am sorry. What I did was the following, just so you know. I took the transcripts that, and by the way, I want to thank Bill Fitzpatrick. Apparently, people on his staff also went to some lengths to secure some of these transcripts, which was important. So we would at least have a sampling here. I took the transcripts, there were 11 altogether, as you mentioned, Brian, one of which I'm sort of not considering because it involved rabbit hair and a rabbit hair coat. And although the remarks may have been inappropriate in the testimony because it's rabbit hair, it just sort of, I'll leave it out. Of the 10 remaining transcripts, we sent it out to people who applied the FBI criteria, and on those 10 transcripts, they found that 5 would have been in error, meeting one of the 3 different error criteria. Applying the criteria utilized by the folks in Texas, they determined that 4 of the 10 would require notifications. So there's only a slight difference between the 2 applications. If you then also consider the 2 transcripts that I gave this commission to first kick this thing off, which were the 2 transcripts from cases in New York State where people were actually exonerated through DNA, that would mean that at least 7 of the 12 cases that were reviewed, with 6 of the 12 using the Texas criteria, would be an error or require notification. Thank you for securing the criteria that are used by the FBI. It's very helpful, and hopefully folks have had a chance to look at it. The one thing we don't have here for the membership, Brian, is we don't have the criteria that are being used in Texas, which I'm sure they will provide the commission, since they recently provided me with it a couple of days ago. What I would suggest we do going forward now is when I looked at the criteria of the two hair reviews, they are fundamentally very, very similar. There aren't any kind of significant differences, with one possible exception. The one possible exception is that whereas the FBI, not in the criteria, in the way they approach cases, because frankly, both reviews do look at the context in which the statement is made. And if a person says something 2 lines later that reverses an inappropriate statement, that would not count as an error, given my understanding of the FBI, and that would not count as an error given my understanding of the Texas approach. But the one fundamental difference is that whereas the FBI acknowledges that it's erroneous and exceeds the limits of science, for an analyst to say that it is very unlikely that this hair would have come from someone other than the defendant. In other words, not claiming uniqueness, but simply claiming rareness, okay? That statements which indicate rareness or an unlikelihood are deemed scientific error, not just by the FBI, but by the leading statisticians who submitted documents to the FBI. At the Texas Commission, what they say is that it's not necessarily scientific error, but it falls into a pot of statements that might be misleading and would warrant flagging and then further consideration. So that's the only real difference between the two approaches. I think what we should do at this point in time, which makes a lot of sense, is I don't think we can hammer this whole thing out in this large body. I think what would make sense is we set up a subcommittee initially to look at the hair review issue, comprised of Bill Fitzpatrick, Kathy Corrado, Marvin, and myself. That what we do is we make a point of getting together on the phone as often as possible between this meeting and the next meeting, and that during that time we can come up with our own New York protocol, which basically harvests the best from Texas, the best from the FBI, and we can also come up with a protocol that will recommend how we go about then evaluating individual transcripts, what the criteria or guidelines should be, what the procedure should be for a notification when errors are identified. And we can then return to the commission with a proposal. So once the 4 of us reach a consensus, we can then come back to you with a proposal with a kind of soup to nuts approach, and then discuss that with the whole commission at the next meeting, and the commission can improve upon it, and then maybe we can get this thing moving. But I don't think it makes sense to go through every nut and bolt in such a large group. I don't know if that's acceptable to everybody there. A couple of the members of the subcommittee are sitting there, so they should probably weigh in.
One thing I'd just like to insert is any subgroup, I agree with the idea of a subgroup looking at these and coming up with them, but I really think we need to have some experts involved in hair along with that. And I think there's some examples that came up within the transcripts that we reviewed that need to be viewed within the context of an expert, so they can support or refute a specific area that needs to come. So I think any group that is looking at these transcripts, and both Texas and the FBI actually have experts involved in that review process, and I think we'd be remiss in not doing that as well.
Well, I'm not, you're missing my point. I'm not disagreeing with you. It may very well be that when we come up with a group that will actually review transcripts, that would include, let's say, a hair expert, and it might include a professor of statistics as well. But I'm not saying that our subcommittee needs those people. Our subcommittee is simply going to think, what that committee should look like. And I think your suggestion that the ultimate review committee includes somebody who has expertise in hair microscopy is a good one. But I think we can, just like you can figure that out, we can figure that out. But right now, what's really lacking is any kind of, written protocol for New York on how to proceed. And I think that if the four of us talk about it, we can actually reach a consensus on it and report back to the whole commission.
Bill and Kathy?
I mean, I guess my thought is that, I think this will come up later when we talk about the probabilistic genotyping, but I also feel there's a danger of not having technical experts at the very beginning. I think we need some technical experts in that conversation to make decisions about what protocol we're going to do and what the issues are that we're looking at. I think they really need to be in their beginning. And the TRACE technical working group previously had provided NICLAC with some suggestions of forensic microscopy experts that might be willing to help out with that. I have those names if anyone's interested in that. I'm sure we can ask them for some other suggestions. But my thought is we need to have an expert on the committee right from the get-go.
Well, Kathy, that's fine, and if that's how you feel, because you have been working as a member of this subcommittee, I'll accept that. I also think then we should have an expert, as you mentioned, the issue of probabilistic statements is going to come up. We should also have an expert in statistics, since frankly, all the errors that have been identified, both in Texas and the FBI, have to do with probabilistic statements and whether or not certain statements exceed the limits of statistical principles or statistical science. So I'm happy to have our subcommittee have two people. If that's, I don't know is there a rule on that, Mike? Can the subcommittee have two people on our committee who aren't members of the commission?
Are we allowed to have subcommittees?
Well, they're not also committees.
They're working groups, right?
Yeah.
Yeah, technically, I don't think there's any authority to have subcommittees, so we can have working groups.
Okay,
Yeah,
so and our working group can have outsiders?
I don't think there's anything that prohibits it.
Fine, so why don't we do that? Why don't we just say that the four of us will be supplemented by two other people, one who has expertise in microscopy, and Kathy, I'd be happy if you could do the research and find such a person and add that person to the group, and I can find somebody with a background in statistics here in New York State who could serve that role as well. The only thing I would ask is, in case we decide to meet corporally, you find somebody local. If you can, unless you feel there's like a conflict of interest locally, you need to go outside the state.
I guess I'm not comfortable with individual members of the commission just picking experts who are going to be involved. If you want me to pick them, that's great. I'll pick them. If you're not comfortable with that, then I think the whole commission's got to be involved in that decision.
Well, if you think the whole commission needs to be involved in finding a couple of...
Unless you have a comfort level with me doing it, Peter.
Michael, actually, I don't think you have the expertise in either microscopy or statistics to do it.
So neither one of us have a comfort level with an individual person doing it. So I think then the default is that before we put people on this group, the whole commission's going to have to do it.
Maybe I can just ask a question. I'm still unclear as to why the statistician's needed, because after reviewing 11 transcripts, I don't see a single one that involved any statistical conundrums. I don't know if anyone could comment if I missed them. I thought I read them really thoroughly, and I don't...
Before we even get to this question, I want to give Bill a chance to weigh in on the whole idea of whether or not, what do you think about the idea of the subcommittee to start with?
My takeaway from the report, which I provided to everybody, was that there doesn't appear to be anybody sitting, of these 71 people, sitting in state prison unjustly as a result of hair testimony. I don't understand why if we identify a case where hair testimony was offered, regardless of whether we think it was outside the bounds of scientific propriety or not, why don't we just notify the defendant, the defense counsel, and the trial judge on every case that we know of? I mean, I would hate to say, on behalf of Mr. Pugh, just to pick an example, who I thought that hair testimony was probably one that went certainly over the top. We would all agree on that. But the guy confessed. His fingerprints were found at the scene. The victim's jewelry was found both on his person and from an individual he had sold it to. So, but that's not my call. That should be Mr. Pugh's lawyer's call as to whether or not he thinks, the hair testimony tipped the scales beyond a reasonable doubt. I don't think that, looking at the transcript and the trial itself, but why do we need to sit around and discuss that case or other case? Let's just notify people if we become aware that hair testimony was offered.
I'm sorry, I couldn't hear your last word, Bill. You said, let's just notify people if we become aware of what?
If any case where hair testimony was offered.
Well, I think, frankly, we could take that up I think we should take that up in the working group first, because, there is a suggestion that came out not just from the Attorney General of the United States, but also from Asclad Lab, that that states should conduct their own reviews to see whether or not the testimony that was given in hair cases was appropriate. I think we should go along and do that, and how we go about doing that, our working group can resolve. I agree with you that we should not get bogged down in the questions of materiality. That's a legal question, that's a just question, and neither Texas nor the FBI gets bogged down in materiality. But I do think that a court would want to know, perhaps in a close case, whether or not a determination had been made by a reviewing board that the testimony on hair in a particular case was scientifically valid or invalid. That might have repercussions in a close case. So the judge would want to know that. And I don't think the court is going to want to have experts in every single case weigh in as to whether or not the testimony is appropriate or not. I actually think that's an oversight responsibility of the New York State Commission, and I think we can do it. But to the extent that you see it differently, Bill, I think we can work all that out in our little working group as opposed to here. With respect to Michael's idea about picking the experts, it's what we could do very simply is to save time. Okay, we could propose a couple of people, and we could simply, circulate those names amongst the commissioners, Michael, and see if anybody has any problems with them. And if they do, we'll go back to the well and get somebody else. I don't expect it to be that controversial. What I was concerned with, frankly, was not controversy. What I was concerned with is people who are sufficiently knowledgeable about who the right people would be.
Yeah, I just think that we're going to run afoul of the open meeting law if we do it that way.
Well, are you saying though that you don't trust me to find somebody knowledgeable in statistics to help out the working group?
I think that everyone on this commission comes to this commission with a different viewpoint. We all sit in different chairs and look at things differently, and having one person on this commission who comes to the commission with a particular viewpoint, picking the expert in a group of 6 people who, under your proposal, would be making some pretty significant decisions, to me, doesn't sound like a good idea.
I guess before we get to the
the way you phrase it makes it very personal, and that's not
I actually think
the way I'm. I personally don't think the scenario you spelled out is a good idea. But I think some other people here have some concerns they want to voice, or some comments they want to voice before we move on. I want to give everyone a chance to speak. So, Ann?
I'm going to ask that we revisit the issue, sort of how we got to where we apparently are of creating a subcommittee. I'm concerned. First of all, let me say I don't think anyone should languish in the criminal justice system who's there wrongly. But I'm concerned that we're overstepping the authority of the commission. The commission was created in the mid-1990s. I would delete any case prior to 1990 to 95, 96, the creation of the commission. We don't have authority over what labs did prior to that date. I would then think, and we may have done that and I'm just forgetting, that we would filter these cases by outcome. If the person pled guilty, if the person confessed, if there was DNA evidence, if the case was dismissed, we delete it. It's not for review. There was no consequence to the analysis. Right? Not based on this analysis that the person is in prison. By my count, that limits us to no more than 5 testimonies, because 5 of them are pre-1994. Just by date, they're eliminated. If I look then at the others, yes, I agree there are some that overstated what a consistent pattern may have been. But I would filter those then by outcome, like you did, Fitz. You looked and you said, he confessed and there was plenty of other evidence. Right? Now, the notice, if we're going to give notice at all, is, in my opinion, is a generic notice. Hair analysis today is questionable, right? Every court should know that. Every defense attorney should know that. Every DA should know that. Beyond that, we're not talking about lab accreditation. Period. Now, if we want to set new standards for hair analysis, trace analysis for lab accreditation, fine. But that's at the level that this commission works, not at the retrospective review of individual cases. That's not our authority, in my opinion. Now, I think we let the defense attorneys know, we let the DAs know, we let the court system know, and if they probably do know, if they're keeping up on evidentiary, that hair analysis is subject to question. Period. We're done. The time and effort and energy spent to date is horrific. I'm sorry. The staff of the office, the time of the commission. I don't see a productive end to the effort. I'm sorry. My opinion.
I guess a related question or concern I had, Peter, when you were talking about the concept that courts would want to know if this commission decided that there were issues with the scientific validity of testimony related to hair comparisons in a particular case, does that mean that we would then be called or potentially be called as expert witnesses in those cases if we're going to start issuing opinions that judges would be interested in knowing in the context of these individual cases, which, again, I think would put us in a position we've never put ourselves in before. It seems to me would get pretty far away from what our charge is.
Michael, no, I think there's an assumption that's not right there. I don't think, and we can work this out, that's another thing we can do in the work group, is I don't believe it should be the commission that decides whether something exceeded the bounds of science or not. I think the commission can establish a review entity that will review these cases, and that review entity can have people, as Brian pointed out, with the requisite expertise in the appropriate fields to make those determinations. I think that what Ann said is somewhat surprising, because I think it ignores the fundamental obligation that laboratories have to make corrections when errors are identified and to notify the appropriate people who may have been affected by those errors. I think that's a question of fundamental professional ethics for laboratories. I think that's frankly a fundamental ethical issue for all of us who are stakeholders in the criminal justice system. That having been said, and you should also realize that the few cases that have been looked at so far are not the pool of all the cases involving hair microscopy during the affected period. It's just a random sampling of the first few from each decade from the laboratories that were able to find the cases. There was not a determination made that there was a determination made that if DNA testing was done, that those cases obviously would not be considered. I don't think that applies to any of the cases that are before us today. I think that all the questions that you're raising, that everybody's raising, are good questions, but I don't think that they're going to be worked out here. I think they can be worked out in the work group, which can have a couple of experts, if you will, as well. What I want to do, though, Michael, is save time. And if you don't feel that I can select an expert in statistics and Kathy can select an expert in microscopy, then perhaps what we should do is we could do this, is that Kathy and I could each make some recommendations to you, and you can reject those recommendations and come up with somebody else. And if all of us are fine with the people you came up with, we can just move forward at that point. If there's a problem, we'll take it back to the commission. But if we don't have any difficulties or objections with the people you come up with, that's fine with me. I just want to save time. So I'm happy leaving the final decision to you, as long as we can agree on it. The final recommendation to you, as long as we can agree on it. Is that a workable compromise, Michael?
Well, before we get to that, I'm looking at Section 995B of the executive law related to the powers and duties of the commission. And, Ann's comment about, if we wanted to set new standards or methodologies for doing this kind of testing seems to fit squarely in there if you look at subdivision 7. But I'm struggling to see where, this idea of issuing opinions on individual cases about the scientific validity of work in an individual case fits in with any of the powers or duties enumerated there. So I guess before we even get to the makeup of the subcommittee, I think that we need to think about, what it is we're doing here, what the end result is, and how that fits within the powers and duties of the commission. Because I think, at least my personal feeling is what's being suggested is starting to get a long way from what I read our statutory authority to be. And, if you have thoughts or can point me to a particular area here in the statute that you think would allow us to do that kind of work, I think that would be very helpful.
Well, Michael, I don't have the statute in front of me. I will say this, and I think I'm actually somewhat caught off guard by this kind of tact at this moment. We had a long discussion of this body on more than one occasion where we decided to move ahead thinking it was appropriate for this body to pursue some kind of review of the hair cases in light of not just what the FBI was doing, but in light of the letter that we received from ASCLD Lab, or that all the labs received from ASCLD Lab, suggesting that states undertake their own reviews. Given that, we decided that we would begin the process of doing so, and no one at that point said, oh no, we can't do it because we don't have statutory authority to do it. So you're raising something new now and different when those of us don't even have it in front of us. I think that's another reason, frankly, if you want to actually go back to that, okay, and walk away from the review that we had previously agreed to do, Michael, that's another thing that the working group can investigate between now and the next meeting. It would be criminal for us to simply use this as a means to further delay the ethical obligation of correcting errors and notifying appropriate parties. It really would be. And I think, given the fact that the working group has Bill Fitzpatrick, has Kathy Corrado, has Marvin and myself, it's certainly a cross-section of this commission represented. And to the extent that the issue that you're raising right now, or that Ann is raising, concerning legislative authority, certainly we can take that up as well. and we can report back to this commission. But we're not going to decide this or even discuss this right now because many of us don't even have in front of us the statutes, the legislative history, or any of the other documents that would be appropriate to have the kind of reconsideration that you're bringing to the table right now.
Peter, first of all, it's not a tactic. You know, one of my jobs as chair, as I see it, is to make sure that we are operating within the statutory authority that we have. So to the extent you think that's a tactic, I take offense with that. I think I'm doing the job that I need to do here. And secondly, I'm not suggesting that we walk back from anything, but what I heard today was a suggestion that we take this into areas which I never heard anybody suggest before, and that is that we, in effect, as a commission, provide expert advice that judges will want to hear in the context of deciding individual cases. And I didn't hear, and if I missed you say that before, I apologize. That's the first time I heard anyone suggest that that was the end result of this process, that that's where we were going. And, you know, frankly, that statement of yours caused me a lot of concern because I felt that you were now suggesting we take this into an area which no one had suggested before. So I'm not suggesting we walk back from what we've done, but I think we need to be thoughtful about where we're going with this. What is the end result? You know, what can we accomplish within the confines of our statutory authority? What is it that we want to do, and what is it that we can do? So if your suggestion is that we appoint a working group to come back to this commission and make recommendations on the commission about, you know, where we should go from here, given the information we have so far, and how that fits in with our authority, you know, that's something that makes sense to me. If, you know, you're suggesting that we, you know, move off into this area of starting to provide, you know, case level guidance or advice to judges that they'll want in deciding individual cases, I'm not comfortable taking that leap right now.
Well, let's say this. We can certainly, the working group can take up, you know, whatever issues fall within this broad range of related issues to the hair review. No one is suggesting that our ultimate goal, I think you took my words out of context, Michael, are to provide expert advice. I think Bill Fitzpatrick summarized the reality quite accurately when he talked about one particular case. I mean, in the sense is that in your review committee, if it had the appropriate subject matter experts, could decide that in this particular case that the testimony, you know, it exceeded the limits of science and was inappropriate. But first of all, the lawyer could say, hey, look at all the other evidence. There's no point in going back to court with this. Or they could decide they want to go back to court. The prosecutor would then obviously oppose it and say that whatever happened here is not material. And a judge could so decide. It's not us advising courts. It's us fulfilling, as I said before, the duty to correct and to notify. That's all. What lawyers then do with that notification is their business, not ours. That's what I thought I said. That's what it all means. But that's beside the point. Right now, we should simply allow the working group to do its work to the extent that people would like the working group to take up and think about specific other questions like the one that Ann raised or the one that Bill raised. Our working group can do all that, and we can answer all these questions, come up with recommendations, and come back to the next meeting with recommendations on how to proceed. That's all.
I guess I see three large questions that I think need to be answered in my mind ultimately by the commission as opposed to a subcommittee or working group. You know, one is what standard we're doing a review, but we've never decided what standard it is that we're using to review. Brian provided some documentation about the FBI standard. You mentioned that you had obtained the Texas standard. I don't know if that's something that you have in writing that you can share with the rest of the commission members. But if it is, I think that would be helpful because I think the commission as a whole has to decide, you know, do we want to use the FBI standard? Do we want to use the Texas standard? Do we want to use the standard that I think was suggested in an article by David Kay that was sent around? Do we want to use some other standard? But ultimately, at the end of the day, I think that's a decision that, in my mind, at least the entire commission should make, and not a working group comprised of commission members and non-commission members. I think the second issue for the commission is, if we're going to do a further review, what's the process? And you've suggested this working group, and I think there's probably some form of that group that people would be comfortable with in terms of a process. But then I think the third question is, where are we going? What's the end goal? As a commission, what do we intend to do? Is it a blanket notification, as Bill suggested, that we're going to make to defense attorneys, judges, and prosecutors? Is it some kind of statement that we're going to issue that we want judges to use in context of a case, saying we think there's a problem with the underlying scientific basis for testimony? So I think those things, to me, I see the value in a working group, but I also see some questions that I think really need to be decided by the entire commission. I'm not comfortable kicking the issue, for example, of what standard is going to be used to a working group. I'm happy if you want to have a working group look at those issues and bring back recommendations to the commission. But at the end of the day, I'm not comfortable giving up the control of those issues to a working group. I don't know how other people around the table.
Michael, I agree
Yes.
with you. Okay,
All right.
and it was never intended that a working group would usurp the authority of the commission. All the working group will do is, it's a smaller group of people, it's easier for them to get information and discuss these things. And they will simply make recommendations and report back on the 3 issues that you just named, as well as perhaps other issues that come up during the meetings. And then the commission will decide to accept or reject the recommendations of the working group, or to come up with an alternative approach. But all it was ever envisioned is that the working group would simply do the legwork, roll up their sleeves and do the legwork, and then report back to the commission. The commission would vote on all 3 of the issues that you correctly identified, as well as any other issues that the working group thinks that the commission needs to vote on as well.
And I guess then, if that's the case, I don't see the need at this point to have the experts on that group, because it's not, those issues don't involve looking at a transcript and needing the expertise to say, is this double shouldering something that's so rare, or how should we consider that? We're just talking about process here, and to me, I think that's a working group of commission members. But again, I'd be interested in terms of how other people around the table feel here. Ann?
I guess I feel like if the end game is to notify defense in cases where hair testimony was offered and the person wound up in jail, and we're not going to make any conclusions about whether it was material or not, then we could go with Bill's approach of just looking for cases where hair testimony was offered and notifying people, and they decide whether it was material or not, and we don't have to classify it as a type 1 or a type 2 or a type 3 error. We just say, here's a notification that hair was involved in this case.
Yeah, there's a website you might want to look at that discusses the issues. If you're an idiot and you haven't done that already and you want to make a 440 motion, knock yourself out.
And it seems like that, identifying those cases would, that work would fall heavily on labs and district attorneys, it would seem to me.
Well, I'm not, we got 71 cases here. Is there anybody that thinks that one of these 71 guys is, I think they're all men, is unjustly sitting in jail as a result of hair testing? I don't see it. But I don't have any problem with notifying Mr. Pugh's lawyer that, hey, there was some hair testimony offered at your trial. You might want to be aware of this website and protect his rights. And what else can we do?
Ann?
Well, two things. One, for the record, I have consistently raised the issue of the authority of the commission and the dates of some of these testimonies and why it was we were looking. I absolutely agree. It's an ethical obligation of a laboratory to identify errors and correct them. That's why we went to the labs and said, look at your files, find the cases where you made overstatement or incorrect report. Yes, it's your obligation as a laboratory to fix that. I don't have an objection to looking at resolving process or review criteria or what, if anything, we're going to do, but I absolutely agree that should not involve review of individual cases until and if we decide we have the authority to make comment on individual cases. Personally, I don't see it. If a working group's going to be created, I'd be happy to serve on the working group as an opposing view.
You can have my.
In New York.
Anyone else have any comments?
Yes, in New York.
I think Marvin's got.
Oh, Marvin. I thought you were adding that to the end of Ann's comment.
I have no problem with New York City.
Yes,
I
Marvin.
can assure you I was not adding to Ann. A couple of points, Michael, that were made in your speech and in David's passage. First of all, as to the issue of whether any one of these 71 people who's still in prison is there unjustly, and your question, does anybody think that? The answer is, I do. My concern is that of
What
a
case?
commission member who has a background in defense work, and my position has always been that when you have wrongful convictions now topping out at 1,669 nationwide, and New York, I think, is third with 83 wrongful convictions and climbing, I come to the conclusion that based upon what we know about hair comparison and its testimony, and what we now know about DNA, that yes, some of these people may be unjustly in jail as a result of convictions where this type of evidence was offered. That's just my opinion, and I think that's a fair inference that I can draw, just as you, as a prosecutor, come to the conclusion that there is nobody unjustly in prison of these 71. Secondly,
First, well, you're on that point. Can I ask you a question about that point?
Bill, can I just finish?
No, absolutely, but
I'm happy to hear your point.
I'm just curious, which of the 71 are you referring to?
I would look at all 71 cases. I've taken a look in particular transcripts.
But why did I waste my time doing this? Some of these guys are dead. Some of these 71 cases were dismissed.
Where anybody is left in jail.
Okay.
It's in jail currently.
Then let's tell their lawyers that there was hair testimony offered at trial, and there's been some serious errors by the FBI. You might want to review them. What's wrong with that?
There's more than just a duty to notify. There's a duty to correct. That's how we got into this situation.
Now I'm realizing what this is really all about.
I'll wait till you're finished, Bill. I'll wait.
I'm done. Go ahead.
No, you have the floor, Marvin.
Sorry.
Thank you. Secondly, Michael, I think it's a straw man argument to say that the working group was going to make recommendations, would make recommendations, and ask the commission to accept a recommendation on specific cases. I've been a member of the working group from the start, met with the other members, and that has never been the tenor of any of the discussions. In fact, the tenor of the discussions was 180 degrees the opposite way. We were trying to figure out what happened with the cases, to look at the transcripts and see the testimony. Third, with respect to comments by Ann about the authority of the commission, week in and week out, month after month, and in my case since September of 2010, this commission on a daily basis has evaluated hair analysis and criteria and nonconformities found by ASCLD lab in many of the labs with respect to hair evaluation and corrections that needed to be made. This falls within our purview. One of the things we want to take a look at, and it's clear from these transcripts, it's brutally clear, that there is a serious question in the testimony, both on direct as well as cross. And I would refer you to transcript 8, page 13 and on, where witnesses talk about the range of characteristics and are repeatedly asked, are there statistics? And say, there are no statistics. Or there is consistency, but we can't say how much consistency. That over and over again in these transcripts, you find these references, these vague references, to a conclusion put before the jury that asks them to believe that the hair comparison resulted in an identification with respect to the putative defendant. And yet, notwithstanding all the directs and all the crosses, witnesses, expert witnesses, could not say with any definiteness or any specificity what they were talking about when they said range of characteristics. So it seems to me, and in keeping with your statements, Michael, that we evaluate in a working group the standards of the FBI, the standards in the article you referred to, the standards in Texas, that if you want a working group to understand how those standards work, surely the professional thing to do would be to have experts, as Dr. Corrado suggested, experts in hair, microscopic comparison, and statistics. What could be wrong with that? That could only inform the working group so that if the working group makes recommendations to the whole commission, and the whole commission asks us questions as to what's behind these recommendations, we can say with some feeling of knowledge and completeness that we considered what experts had to say. And in fact, we could produce those experts before the entire commission so that all the members of the commission who would vote on any recommendations would be able to have their questions answered. And in the final analysis, Michael, the statement that you're uncomfortable with the fact that we might be called as witnesses in a court of law really has very little to do with the workings of the commission. The fact is that the commission goes about its business. It makes recommendations. It makes decisions on a weekly, monthly, quarterly basis. And if defense attorneys and prosecutors want to call us as witnesses, then that's for a court of law to decide as to whether or not we are experts and whether or not we have an opinion to offer. I would remind you, Michael, that the DNA subcommittee, which is a subcommittee statutorily of this commission, found that low-copy DNA works. And that resulted in a number of briefs, both in federal and state court, by prosecutors in this state who claimed in Fry hearings that the relevant scientific community, namely the DNA subcommittee, had decided that this was valid evidence. That did not stop prosecutors from using the results of a DNA subcommittee in their briefs, which is fine. Some judges bought into that. One judge in particular, in an erudite decision, did not. But the issue of what we say and what we do is for courts to decide. And finally, I would be opposed. So there's no question in your mind, Michael, or any member of the commission, I would be opposed to making specific recommendations from the working committee or from the commission on specific cases. That is not our business. Our business is simply to say, we've looked at hair evaluation, we've looked at these testimonies, there are standards that can be formulated, standards that should be adopted in New York, and that's what we, the commission, say. Under that rubric and under that template, the various forensic laboratories in the state of New York can take a look at the commission's recommendations and either adopt or not adopt those standards in their work in their particular labs. Whether those labs are right or wrong will be determined in a court of law by prosecutors and defense attorneys who will argue before juries and judges that the Commission on Forensic Science adopted these standards, that laboratory X, Y, and Z adopted them, and that laboratories A, B, and C did not. And then juror number 7, who must determine the guilt beyond a reasonable doubt of a specific defendant, will make his or her decision based upon all the evidence, including the hair evaluation testimony of the forensic expert. That's all we're trying to do here, and nothing more and nothing less.
Just very briefly, I actually agree with Commissioner Willie. The reason that I have pushed the envelope in this matter in meetings past was because I thought that this was an exercise by this commission to see if faulty science had led to the unlawful incarceration of any citizen in the state of New York. And I am comfortable in looking at these 71 cases that there are nobody in amongst those 71, whether they're incarcerated, whether they're out, that has been wrongfully convicted as a result of hair testimony. That's not for me to say unilaterally. That decision should be made by an independent judge. So I have no problem on transcript 8 with notifying Mr. Gormley, who, in addition to having hair testimony presented at his trial, also had DNA testimony concerning his semen presented at the trial, also had his confession presented at the trial. I don't feel uncomfortable saying that Mr. Gormley was properly convicted. If there was somebody amongst these 71 completely independent of my obligations as a commissioner, but consistent with my obligations as a district attorney, regardless of whether it was my county or not, I would make every effort to reach out to the defense attorney, to the judge, to the defendant, him or herself, to notify him that something wrong had occurred. With that said, again, I get back to my point. If this is an effort to further embarrass the FBI and further attack forensic science, count me out. If this is an effort to make sure that nobody is wrongfully incarcerated and that their lawyers are properly notified and that they themselves are properly notified, count me in. That's all I really have to say about the issue.
So,
Wait, and there's a couple other people here that have been trying to get in.
I guess in listening to the conversation, I'm really of the opinion at this point that we've done a lot of work on this, the labs, the commission, the Office of DCJS. I read through those transcripts, and I think we could probably have a day-long argument as to whether or not what the person said was appropriate or not, whether the questions asked of them were appropriate or not. I think the end of the day is we've generated this list of cases that had inculpatory hair testimony. That's the bottom line. If a person was convicted, I agree with what Bill said. I would put a motion forward that we continue in that vein. If a case is identified with inculpatory hair testimony, let's notify and let someone else look at it on a case-by-case basis. We're never going to agree, and I don't think it makes sense to spend our time deciding what's an error, what's not an error, like Ann said. I mean, at this point, it has to be decided case-by-case. Let's just move forward with what we've been doing. Identify those cases, notify the appropriate people, and we've done, as I'm concerned, we've done our duty as the commission and as the laboratories. If the laboratories are identifying the cases, then we're putting them forward, and I think we've done our duty there as well.
And just to make sure I understand what you're suggesting, are you suggesting that we continue with the inquiry that we've done so far in looking to identify through the labs what cases were submitted to the labs where the labs did hair comparison and made a positive association, then take that universe of cases and follow up with prosecutors or courts to find out of those, where were those associations used in court, and where we find a case where a New York State laboratory under our jurisdiction issued a report of a positive hair association, and B, testimony regarding that was used in court, that we then make a notification to the parties involved, maybe along the lines that Bill had suggested about questions have been raised, here's websites you might want to look at, and that's, in essence, the end of our analysis.
I think so.
Not
I mean,
analysis, but the end of our work.
I think it's a huge burden on the labs, and, I apologize to the labs that are going to have to do this work, but, I read through those transcripts. I honestly didn't see anything that I thought stood out as horrific. But obviously, other people have concerns, and I think that's the problem. I don't think we can say, I don't know that we're ever going to be able to say, well, we've looked at this random sample and we're all good or we're all not good. So at this point, I think you have to look at each case, and that's not for us to do. So yes, the way you said it, I think it's very eloquent, and that would be what I would suggest.
Kathy, just
Peter, go ahead.
respond to that.
Absolutely.
Thank you. So Kathy, I mean, one of the things you should know is that despite the fact that you said people can disagree about whether errors are made, both the FBI hair review and the Texas Commission's hair review, there's a meeting of the minds, and then people ultimately agree once they come up with a certain criteria as to whether or not something was inappropriate or something was appropriate. So although people can disagree, they can actually work out those disagreements and actually issue conclusions on all these individual cases. They're doing it, and I think the proof is in the pudding, if you will, that they're doing it both at the FBI and in Texas. So I think it's easily something that can be surmounted. What you're suggesting is, though, that, remember, all we did initially is we asked the labs to, I think, I can be corrected if I'm mistaken, come up with like the first 5 cases of each decade of the 80s and 90s and do nothing more. Obviously, one of the things we would be doing is now be asking the laboratories to go back and pull every hair case which meets certain criteria that we would decide. I think that's a good issue for us to discuss as well, Kathy, in our working group. But I think all of these questions can be worked out in the working group. And all we're going to do is make a recommendation at the next commission meeting on how to proceed. Based on your most recent concerns, hey, you may carry the day in our working group about how we should proceed. Bill Fitzpatrick might, and then we'll report back. But I don't think, first of all, I don't think we're not going to resolve this today. We can't resolve this today, number one. Number two, I do believe that the working group can go back and try and come to an agreement on the 3 issues that Michael raised, namely standards, process, and what is the end goal, as well as additional questions that Bill has raised, that you have raised, that Marvin has raised. We can do all that. And all I'm asking is that you give us the opportunity to do it, Mike. So my motion is, at this time, that the working group, meet as often as necessary between now and the next commission meeting. Agree to try and answer your 3 questions as well as the questions that other people come up with, and report back to you. If we can make recommendations, we will. If we can't make recommendations, then our report back to you will be that we can make recommendations. But rather than just keep flogging at this thing at the whole commission right now, I think that's a more efficient way to proceed. I think the only outstanding issue, frankly, is for the working group. Do we go with Michael's approach that because we're not going to be evaluating cases, that it should be just the commissioners on the working group, or whether you want to bring in a couple of experts to enhance the working group. But my motion is that the members of the working group go out and now investigate the issues raised by Michael and others, and report back with recommendations, if possible, at the next commission meeting.
Kathy?
I would just say if we're considering that I think it would make more sense perhaps to replace me on that working group because I will not be on the commission after this. And I think if it is going to be an ongoing issue, it might make sense to put perhaps Scott O'Neill, since he will be my replacement.
The only problem, Scott's not a member. My thought was Ann has volunteered, and I had the same thought. If Scott's appointment goes through partway, between now and next meeting, we're in a spot where we don't have a commission member on. So, I think if we are going to appoint a working group, it would make more sense to have Ann on to me than you.
I appreciate that, but I would ask if we could at least have a lab director represented there. Maybe it doesn't have to be a commission member, but I think I would appreciate it if at least one lab director could.
Why don't we do this before we get to the makeup? Well, I don't know. Maybe the makeup of the subcommittee or the working group matters to people in terms of how. But Peter made a motion.
I second.
And Marvin has seconded.
And just to clarify it, Michael, certainly the composition of the working group could be modified. That's not part of the motion, obviously. By the way, Kathy, we couldn't hear the beginning of the meeting here. Are you simply leaving the commission, or are you leaving your current position at the lab?
I'm just leaving my position on the commission. My term of 9 o'clock chair has ended, so therefore I would leave the commission, but I will still be lab director.
Oh, okay, thanks. Okay, good.
Unless you're offering me a job.
Peter, a friendly amendment.
Heard that.
I would just say that Peter should contact anybody he wants on the commission. They can respond to his emails. They can make their own recommendations, and then Peter should be allowed at the next commission meeting to present his recommendations on how we go forward, and we either vote them up or vote them down or modify them.
Oh,
Well,
and the other, it wasn't in the form of. Hang on, Peter. The other thing that's on the table, and it wasn't put in the form of a motion yet, but Peter has articulated one path forward between now and the next meeting with the working group. Kathy has articulated another path forward. And I think at some point that deserves consideration too, whether it's now or whether it's, after the working group has a chance to look at this issue is up to the commission.
Michael, so I think my motion should be dealt with. Bill, I didn't understand something. Maybe you can clarify.
Okay, I'll withdraw.
I just thought that the working group should actually, have some at least telephone conference meetings and try and work these things out to see if we can come to some kind of agreement and make recommendations. They shouldn't be my recommendations. They should be recommendations of the 4 or 5 people, or at least a consensus of those 4 or 5 people. And if most people have a different position than perhaps myself, then I'll defer on that. So I'd like it to be a real working group. That's all I'm saying.
All right,
I guess I would suggest this, just so that we know exactly what we're voting on. I would, to the extent it's an amendment to your motion, Peter, I would say that we should pick the people so everyone knows what we're voting on, and I'd suggest, if they're willing to serve, that we have you, Marvin, Ann, and Scott.
And before
Well, also, Bill was on that
Kathy's
originally as
suggestion
well.
is going to be put forward as a motion.
Peter, I'm not going to be much help. I'm getting ready for a murder trial that is going to last a month and a half. And
Bill indicated he did not want to serve. That was the reason that I suggested Scott instead. I guess Peter's made a motion, Marvin seconded it. I think we need to act on that motion. If that motion passes, then my sense is it's not worth voting on Kathy's motion until the next meeting, because to decide how we're going to proceed while we have a working group looking at it doesn't make sense. If that motion fails, then it seems to me the next logical thing would be to put Kathy's motion on the table and see if that motion has support.
I'm fine with the friendly amendment of making Scott and Ann the other members of the working group. That's fine.
All right. Any further discussion?
yeah, could I say why I'm going to vote for this? Because I don't want to be viewed as us. I don't want this commission to be portrayed as thwarting the possibility that an innocent person is in jail. And if we vote against this, that's what's going to happen. So that's the only reason I'm voting for it. And I hope that we can put this to rest at the next meeting.
Any other comments before we vote? All right, all in favor of the motion? Anyone opposed? Any abstentions? All right, one. Guy who's got to do the work is abstaining. All right. I think we did agree on one thing, Peter, and that was that we were not going to put this to rest at this meeting. So thank you for your work on this. I appreciate it.
Just one quick thing. I wanted to thank Commissioner Member Fitzpatrick's office because they were tremendously helpful. There was numerous staff members that worked a lot in not just going through DA's offices, but also through county clerk's offices, and really doing a lot of work on this. So there was a lot of work involved, and they contributed tremendously to it.
Could you put the second person's name on the record, Brian, if you don't mind?
Feel free.
Sarah Fitzpatrick.
Melissa Schwartz and Sarah Fitzpatrick.
I can't
I'm sure there's
forget.
no relation.
I can't forget Melissa. Thank you.
All right, I believe our next item, we agreed to move up the NICLAC letter under number 6A, new business related to the rapid DNA technology, to the next item on the agenda. Kathy, do you want to address that?
Yes, thank you. I'm not going to reiterate the letter. I'm assuming the commission members have read that, but I just want to throw out a few comments about it. This issue came up because the rapid DNA is this new technology that allows the use of an instrument to perform rapid DNA analysis at the scene or anywhere, basically. And there was a concern among the lab directors because we've been contacted. We've also been heard from a lot of the police agencies and the district attorney's offices throughout the state that there are companies that are heavily marketing these instruments to the police departments and the district attorneys. They're doing things like, well, the police department next door is buying it and you're going to be left out if you don't buy it, and this kind of thing. And we had some concerns. If you had a chance to look at the articles that we provided, some of these instruments are being used throughout this country right now. And there's two different ways that that's happening. In some instances, there are police departments that are using these instruments in conjunction with accredited laboratories. They're being trained. They have policies in place, and there's some oversight. But there are also some agencies that are using these instruments without any oversight, and they're basically just hearing from the vendor. It's real simple. Just here you go. This is all you need to do. And I think that we were very concerned because if someone's using this kind of technology and they're not aware of the pitfalls, and again, I'm not going to go in detail through them, but obviously we know there's contamination issues. There could be issues with someone misunderstanding mixtures. And I think the issue that really was the most concerning to those of us at NICLAC was the consumption of evidence. These instruments are not very sensitive, and if someone were to take the one piece of evidence that existed and run it through these instruments and not get a result, or get a result that would not be usable, we can't go back. There's nothing we can do. That would be the end of it. And so we were concerned that if this happened, if there's an agency that started to use this and that happened, that's just going to be a black mark on the instrumentation. It's going to be, obviously a bad situation for the criminal justice for that case. And so we really thought, rather than be reactive and have some bad thing happen that we're all wondering how did that happen, we should probably be proactive and look at, is there something we need to think about these instruments? Is it something that perhaps needs training and some kind of regulation? And as you can see from our letter, we felt like probably the best place to do that would be to ask the DNA subcommittee to kind of review these instruments to see how they work, what the issues might be, and to perhaps suggest some kind of implementation or regulation moving forward if necessary.
Comments?
I agree. I do not know the validity of the science. I've been approached by, I think, 2 companies. Scott, you probably too. That this, in 10 years from now, this is probably going to be something that's state of the art. But right now, I'm very, very concerned about, inexperienced officers in the field making determinations about what evidence should be tested, should not be tested. I'm concerned about contamination. I'm concerned about consumption of the evidence. So I think that's a good start. And then down the road, we're going to have to decide, does this machine in and of itself come under the jurisdiction of the Forensic Science Commission? Traditionally, we do not have traditionally, legally, we don't have the authority to govern evidence technicians. I think that would be nice if we did, but we don't. Is this an evidence technician, or is this a mini lab? But anyway, those are questions for down the road. Right now, I support Kathy's idea on behalf of NICLAC.
I totally support the idea of referring it to the DNA subcommittee and getting their technical review. I think down the road, if they come back with yes, this is analytical performance of an analytical instrument for purposes of generating analytical results for use in forensic criminal investigation purposes. I think our definition of what constitutes a forensic laboratory under the statute is broad enough to encompass a police department buying an instrument, training their personnel, and operating that instrument or any other government-owned entity. For example, by example, in the clinical laboratory world, labs perform testing off-site with lab personnel. Health fairs is the prime example. In the environmental lab industry, the health department regulates entities called mobile laboratories. They have no four-wall physical lab. They have permanent address at which they keep their instruments, sometimes in a van, but the fact that they perform the analysis and generate results that are used for the stated legislative purpose makes them a laboratory. So I think when we look down the road, we have the authority. The only exception in the statute is for fingerprint analysis as performed by law enforcement agencies. If the legislature wants to write an exception for DNA analysis performed at the crime scene, well, they can do that, but they haven't done it yet. And I think we need to look at the technical issues and perhaps then, the regulatory requirements. I have no doubt that the manufacturers and the industry would argue that the accreditation requirements for such an entity might be a modification of our current accreditation requirements, and that would require regulatory amendment, but we have the authority to propose those changes. So I absolutely agree the first step ought to be to send the question to the DNA subcommittee.
And I assume, Kathy, we invite various companies to come before the DNA subcommittee.
I don't know that we can assume. We're going to send it to the DNA subcommittee. I have some concerns with this. First of all, again, if you go back to Executive Law Article 45B and specifically 995, when you look at our powers and duties, I don't read forensic lab as broadly as Ann does, and I think that if you go with the definition she's suggesting, there's all kinds of things that have been happening out there for years that police do as part of the investigation that under her definition we would now have to jump into and start regulating. So I strongly disagree with the definition that was put out. I think that if you look at 995 and specifically 995B, I think you'd be hard-pressed to see where we have the authority to do this. Ironically, though, if you look at the part of 995 that authorizes the DNA subcommittee, that language is much broader than the powers of the commission in certain respects. And it does give the DNA subcommittee the power to assess and evaluate all DNA methodologies proposed to be used for forensic analysis. So I think it's a very bizarre situation, but as I read this statute, the DNA subcommittee probably is authorized to look at this. I don't believe the commission is authorized to look at it. But the only thing the DNA subcommittee can do is make binding recommendations to the commission. But that said, my other issue with this is we're going to kick something to the DNA subcommittee. We're going to say we don't know of anybody in New York State who's doing it. We don't know what instrument we're asking you to pass on. We don't know what methodology we're asking you to pass on. We don't know what protocols are being used. We don't know what proficiency testing has been done. We don't know for what purpose people intend to use it. But please tell us, whether or not, give us your opinion on this. And it doesn't seem to me to be the way we operate. When a lab is going to bring DNA testing online, it seems to me we go before the DNA subcommittee with much more specific information so that they can narrow their focus and they can rule on something concrete that's in front of them. And it just, to me, this seems like something very different. That being said, I don't see any harm, because I do believe the DNA subcommittee's charge is broader than ours. I don't see any harm in kicking the general question to them, but I don't think we should start binding them in terms of who they should reach out to or who they shouldn't. I think it's up to them to decide what, if anything, they want to do with it. And if they want to reach out to companies and do an assessment of every possibility under the sun and every conceivable thing that could happen, and spend whatever time and effort needs to be done at that, maybe to the expense of time and effort that they'd spend at other testing, that's up to them. And if they find another route that they think makes sense to them to deal with this, that's up to them too. They will make, I assume, a recommendation back to us that we can either accept or reject. So I have a lot of concerns about this, both in terms of the Commission's ultimate authority and the vagueness of the issue that we're throwing in front of the DNA subcommittee. If I were on the subcommittee, I don't know that I'd appreciate having it dropped in my lap in this form. But that being said, I would support a motion, to send it to them, but would certainly give them wide latitude in terms of how they dealt with it or what they came back to us with.
Mike, if I could just add one thing to this disagreement between you and Ann. I just want you to think about a scenario which I could easily envision, because I get in conflict all the time with my local police department about who's in charge of the evidence. Well, the Court of Appeals has already answered that question. The DA is in charge of that evidence. I can easily envision a situation in the future, if they were to buy one of these things, where the lab gets cut out of analyzing anything, and everything's going to be analyzed in some mysterious room somewhere with this rapid DNA technology machine sitting there. And I'm not saying you're right or Ann's right, but I'm just saying I would be very, very concerned about us having no authority or control over that. But we'll see. We'll see what happens.
Yeah, I mean, I'm concerned, like Ann's concerned, that, by people developing forensic evidence using the technology, do they put themselves into a situation where they're functioning as a forensic lab? And, if we found out there was, let's say it wasn't this technology, that there was an entity functioning that way, would we step in as a commission to say, you're not accredited, you're not? So I think does the definition kind of make you jump over? I think the technology is moving quickly, even though you may not be seeing it here. It's moving on throughout the country. It's going to hit us soon enough. And I think we've seen the same type of topic recently with ballistics in one of the SUNY schools, where somebody was, developing evidence who wasn't working the ground. And I think it's a similar situation. But I think it's a good idea to send it to the subcommittee, figure out what the technology is about. And then the second part of this is to figure out, if they're developing forensic evidence, are they putting themselves in the position of a lab, and then do we have authority?
I actually think in a situation, if the situation you're referring to is the one I'm thinking of, we wound up with an opinion from the IG that was not, in fact, a forensic lab. But that being said, I think the labs are asking us to have the DNA subcommittee rule on something with a complete lack of definition that the labs would never want to be in that situation. But that said, I'm fine taking this to the DNA subcommittee, but I intend to give them great deference with whatever they come back to us with.
I do think it's not totally without definition, because we do know the manufacturers that are contacting the DA offices and the police departments and the labs.
But are they the ones that someone ultimately is going to use? Is there going to be another manufacturer?
All we could say is this list and any others you want to consider. But it's not without some definition. And I agree the issue of are they lab. Now, we did take the position and notified, I believe it was SUNY, that they were operating a forensics lab without proper accreditation, and they agreed to stop doing whatever they were doing.
Yeah,
That had to
certainly,
do with
one resolution here, to me, would be to notify police departments that if you intend to do this, you need to go before the DNA subcommittee before you do.
Yeah, we can
But
do
I don't know that we have the authority to do that. I think the DNA subcommittee might have. If you read the powers, it's a very strange thing. The DNA subcommittee appears to have broader powers than we do. But so for that reason, I'm comfortable kicking it over. But for example, if the DNA subcommittee came back and said, we don't have enough information to rule on this, but we think if someone's going to use this in New York, they ought to come before us before they do and tell us what instrument they're going to use, what they've done for proficiency testing, what the methodology they're going to use is, under what conditions or circumstances they're going to use it. And then with that level of detail, we could give you an intelligent opinion as to whether or not this comports with the science or not. That would make a lot of sense to me.
That's a start.
And Ann can correct me if I'm wrong, but I believe the way it works in public health law is if you're doing DNA analysis for the purpose of identification, you need a permit from the Department of Health, except where it's covered by this law and the commission. So if they aren't covered by the commission, then in theory, they should be coming to the DOH, which they're not going to have a
They're not going to want to
experience
do
with.
it.
So yes.
I just didn't want my silence to be construed on as assent on a point that you made.
I would never do that to you, Marvin.
Good. On the powers of the commission versus those of the DNA subcommittee. I've actually looked at this myself and concluded that the DNA subcommittee under the administrative law that governs in this state is a subcommittee of this commission. And while its powers are defined, it still is responsible to this commission. The legislature, in enacting 995A, made clear that the DNA subcommittee was subservient to the commission by noting that while its recommendation was binding, and whatever that word means, their recommendations go to this commission, which can reject those recommendations and send them back to the DNA subcommittee. So the narrow reading of what are the powers and duties of the commission versus what are the powers and duties of the DNA subcommittee, and juxtaposing just those two factors without looking at the overall structure of the DNA subcommittee within a commission created by the legislature is wanted. To me, we have the power to tell the DNA subcommittee that this is what it should consider. And we then have the power to hear from them and either reject or accept any recommendations. I disagree with your analysis because repeatedly over the last 5 years, this deferral to the DNA subcommittee as a separate entity that has powers above and beyond the commission is one that has caused a great deal of problems, particularly in the low copy DNA area.
I'm glad that you made that 5 years so that it goes well beyond the term that I've been here. So with that said, I think we have a motion on the table, if I heard correctly, to refer this to the DNA subcommittee. Is that right?
That's correct.
All right. Do we have a second for that motion? All right. We have a second. Any other discussion? All right. All in favor? All right, anyone opposed? All right. And any abstentions? So 1 abstention, 1 opposed. The motion carries then.
Can I ask a related question? It's somewhat related. I don't know. It's not a freestanding matter on the agenda, and maybe Kathy has brought this up with NICLAC in this context. When you were talking about different probabilistic approaches to DNA results, I know, for instance, there have been some new rules that have been uttered with regard to the interpretation of mixtures that went out nationally. And as a result of that, the Texas Commission on Forensic Science is undertaking a review to see what effect, if any, coming up with new numbers will have on cases. Is New York doing anything like that at a laboratory level, Kathy?
Not that I'm aware of currently.
Is there anybody there who can comment on what, if anything, New York labs are doing in response to the new standards that came out on mixture interpretation and the potential consequences of that in actual casework?
What new standards are you referring to, Peter?
I'm not even sure I'm aware of it, Brian. I do know that maybe you're more aware of it than I am, and obviously if Barry was here, he could comment on it because he's been involved in that issue. I haven't been, but I know that as a result of people recalculating frequencies or likelihood ratios or whatever in mixture situations, that the numbers are changing. And I think an effort is being made, for instance, to re-notify council by the laboratories with the changed numbers. And I don't know if anything like that is going on in New York, that's all. Are you aware of it, Brian?
There's nothing currently going on in New York regarding that.
Are you more aware of what they're doing in Texas and why?
The information I have from Texas had to do with certain labs with, I believe it's the combined probability of inclusion, a specific statistic that not all labs in New York are even using. And I think one of the things, and maybe this is your natural segue into the material that we're going to talk about next with the probabilistic genotyping. I believe at the last meeting, Barry was advocating for the the CPI statistic over probabilistic genotyping. And I think what we see from the analysis from the subcommittee, and maybe I'm stepping on the next item.
No, I do think this goes right into our next item. It would be number 5B under the heading of all business. Would you want to continue?
Yeah, so I think what it is you see New York labs are actually moving toward, you've seen, at the last meeting, the Erie County lab moving into SDR mix, and we have the New York City lab with FST, and, the other probabilistic genotyping systems that are there. But, clearly that presentation advocated moving toward those probabilistic systems. And I think the analogy that you want is, while there's different ways to do the combined probability of inclusion that take into account allelic dropout and other things like that, the analogy I'll give you is if you decide now to advocate moving forward with using CPI statistics, it would sort of be like if 10 years ago you couldn't read a document because your vision was blurry and you couldn't see. So being a state worker, I move a little slow. So today, I give you a prescription that was for 10 years ago, and you put that on, you still can't see. So I think instead of advocating moving forward with fixing CPI, I think what New York is doing, and what we've seen through both the commission and the work of the subcommittee, is that labs are moving toward this probabilistic genotyping. And I know from Texas, that's their encouragement as well. The labs are being expedited to move to probabilistic genotyping systems specifically to avoid the problems that are associated with using the CPI statistic.
No, but Brian, what I'm asking is, and I don't know as much about this as you do, but if in Texas they're saying that for the laboratories that use the CPI approach, there needs to be an adjustment in the numbers that were generated, is that what they're saying in Texas?
I think what happened is my understanding, and again, this is third party from just conversations I've had with people, is Texas is still trying to assess what's happened. What happened is certain labs have put out an initial CPI stat a number of years ago. They put out a new CPI stat, which is different. So the question is, which one is right? And right now, if you had a medication issue, I know you're very active in medical root cause. If you had a thyroid issue and your thyroid value is high, and the next one your thyroid value is low, which one is correct? Well, you do it again. And that's, again, where the probabilistic genotyping system is. So I think Texas has not come up with an approach, as I know of yet, of how they're going to handle this. But one of the things they're looking at is the idea of retyping question samples in probabilistic genotyping to see if the more conservative CPI is correct or if the probabilistic genotyping and the first CPI was an accurate representation. So I think this is kind of a developing story, like a CNN banner that's going on, and I think the press hasn't stopped printing on it yet. So I don't know if you want to continue talking about the probabilistic genotyping thing from last time. I know we have the letter from the subcommittee. I don't mean to step on you. I usually do the accreditation part, but
we asked at Barry's request. Barry referred to a article or lecture by Dr. Coble. He sent us a letter. Actually, sent it to the DNA subcommittee. We asked the DNA subcommittee to look at it. In the materials is the letter back to us from the DNA subcommittee, as well as our letter to them and Dr. Coble's letter. Yeah, I think they're pretty self-explanatory, but if anyone has any questions or comments, I'm certainly willing to give them the floor.
I guess I read what the DNA subcommittee's letter said, and what I took from that is that the use of these software tools is a significant advancement and will greatly assist the laboratories in the analysis, interpretation, reporting of complex DNA mixtures. I agree with that, so I think that's a positive step in the right direction. And I guess just a concern that I have is I also read through the letter from Dr. Buckleton regarding the star mix, and I am a bit concerned as far as what his letter states, because I think he's correct in that there were some incorrect statements that were made, and while they may not have been intentionally incorrect, I do feel there's a little bit of an obligation of the commission to correct those statements. In particular, there was the statement that there was a false positive with star mix, and that star mix did not obtain the correct results with the NIST 13 study. And I think, I'm not sure. I guess I think perhaps we need to think about, as members of the commission, that we have to be very careful about making definitive statements about technical issues if we're not, I think I've said all along, if one thing people remember me saying at every meeting consistently is that we need to make sure we have technical experts at the table. And I think that if we're talking about technical things, we just have to be a little cautious in making very definitive statements about things like that, because people watch these meetings, and if there's a false information out there that StarMix made a large mistake and it didn't, that's going to be propagated throughout the community. And I am a little concerned, as someone who is validating StarMix right now, I am concerned that there's some misinformation that's out there. So I don't know if it's possible for the commission to perhaps make a formal retraction of those statements, or just publicly state that according to what Dr. Buckleton has stated, which appears to be correct, that we really don't know that there was no, let me say it again, that there was no false positive in Australia with StarMix, and that the StarMix was able to obtain the correct results with the NIST 13. I feel like it's our obligation to correct that misinformation.
Yeah, I wish Barry were here, but if I'm understanding correctly, you're referring to statements that Barry made. Is that correct?
Yes, I'm not, like I said, I don't mean to imply he made them intentionally. I just think that they were statements, and I can tell you that, other people in the community that watch these meetings heard that and thought, I wasn't aware of that, and so it's being propagated, and I think we do need to correct that.
I understand your point. I just, I don't know that we as a commission have the authority to retract any individual member's statement without that. So I think if Barry were here, we could ask him, that is one of the reasons why the material from John Buckleton is included in the binder. These binders are posted, and I assume this is public, so, if someone does say, wait a minute, this was said at a commission meeting, there's material to indicate from the person directly involved in it that was not accurate. But I understand what you're saying. I appreciate it, and I don't disagree. But I think the only one who can retract the statement is Barry, and I don't know if he can speak.
Is Buckleton's letter, is it public? Because my copy says confidential. So, but it does have it stamped at the top, Division of Criminal Justice Services. So
is this part of the material that's on the?
Yeah, this is on the public web. What happened is, an OFS, when we prepare binders, because there's different levels of information. Everything in these binders is stamped, but then stuff on the web is not as well. So that's available.
So for the webcast record, we can simply state that the commission has received a letter from Dr. Buckleton in which it is stated that it is his information that no false positive was observed. And that letter is available publicly in the records of this meeting.
Why do we have to say that? I'm sorry, I don't get that. Why do I have to say that? It's a matter of public record. If I get a request from a prosecutor or a defense attorney who says, I hear there's something by a guy named Buckleton, he wrote a letter, I have to say to him, man, that it's available, it's part of the public record, go look it up?
No, you don't have to say anything, Marvin.
Available. But I was just, in case people's, not everybody reads all the documents, they listen to the webcast, and for purposes of making that statement, it's now been said.
Yeah, as I said, I think the letter is pretty clear. It's a letter from John Buckleton, and he refers to the statements Barry made. Says, at the meeting, Barry Scheck made certain comments, one of which I write about. Mr. Scheck alleged that a miscode in STR mix had caused a false positive in the Ryder case in Queensland. This statement is incorrect, and then he goes on to explain. So again, I think the documents are pretty clear. I don't think that we can retract anything Barry said without Barry doing it. So, if he's here at the next meeting, we want to ask him to retract it. But otherwise, we've done our best to include documentation here, which we think will give everyone, hopefully, full information so that they can make their own decisions on it. But I appreciate the points you raised. Anything else with regard to either B or C, the letter from Buckleton? All right, our next item on the agenda then, under old business, is an update on the Westchester County Department of Labs.
They'll be participating via phone, and Kathy, you can reach out to them.
Thank you. Just for context, I believe there was issues raised by one or more of the commission members about the physical space at the laboratory, if I recall correctly, and that's what this is about.
That's correct.
Hello. Hi, Betsy. This is Kathy Levine. You're on the speakerphone for the commission. Is Dr. Asher with you?
Yeah, he is.
Okay.
Just if you can for us, this is Mike Green, the chair of the commission. Can you just identify yourself so we know who's talking?
Well, I'm Betsy Spratt, the Director of Toxicology for Westchester County. I'm Dr. Asher, a pathologist medical examiner for Department of Lab and Research.
And there were issues raised at, I believe it was the last commission meeting regarding the laboratory, and I believe you wanted to provide us with an update.
Yes, I did write to you a letter dated July 29th.
Yes, and we did get that letter, and we circulated that to all of the commission members. Thank you.
And we have looked at the space around the lab. I know the lab is a little cramped with all the instrumentation. That's why we moved some of the people into the rooms. And those rooms don't have any instrumentation.
All right. Are you satisfied that the physical space and layout of the laboratory at this time is such that the people who work in the lab can properly perform their duties and can do them in a way that complies with the accreditation standards of this body?
As of today, the answer is yes.
All right. Any of the commission members have any questions? All right, I don't see any, so thank you. We appreciate you being available today, and we appreciate the work that you're doing.
One quick follow-up. Do we need them to continue after this? Because I believe we said that we'd be asking them to give updates at subsequent commission meetings. Do we feel this issue is resolved?
Personally, I don't. I don't feel the need to continue it. I think we raised the issue. I think they've indicated to us they've addressed it, so as far as I'm concerned, it's over. If someone feels differently.
What's your anticipated date of your next surveillance inspection by your accrediting body?
We just had our surveillance in May, so we'll have a mid-cycle in 2016, and they will be on site in 2017.
All right, so we will expect an updated review by the accrediting body in 2017, which hopefully will reflect adequate space and physical plan.
I do think it was the mid-cycle that initially raised this issue, if I remember right. All right, anything further? All right, thank you very much.
Thank you.
So we're on to executive closure.
I believe we've taken care of new business, which takes us to number 7 on the agenda, which is lab disclosures. The first item we have under lab disclosures relates to the Monroe County Crime Lab and an issue with regard to drug weight discrepancy. I think I saw John Clark. John or whoever is with you, do you want to come up and just give the commission a brief outline of this issue? You have to sit next to Bill Fitzpatrick.
Hey, one more strike.
Thank you. John Clark, Director of the Monroe County Crime Laboratory. Yes, that's correct. This was an issue relating to discrepancy in weight of some marijuana. When the marijuana was recovered by the law enforcement agency, they made an initial weight. They submitted it to our laboratory. They noted that our weight was in discrepancy to what they found. Our weight was heavier. They elected or asked us if they could come back in. We re-weighed that evidence in the presence of the submitting agency, the representative from the prosecutor's office, as well as the defense attorney. And we found that the non-conforming work had occurred on our end. We implemented our corrective action, which included taking the analyst off of casework, reviewing or gathering a list of cases that chemists had previously worked on. We recalled 25 of those cases back to the laboratory, reweighed the items, and incidentally, in those 25 cases, there were 78 items that were reweighed, and there were no discrepancies found in those cases. We concluded our corrective action and submitted our findings to AskPlad Lab.
Does anyone have any questions for the Monroe County Lab on this issue?
Mike, before we do, there's a little problem here in New York. We're getting the boot.
We did warn everyone ahead of time that this may happen. I think we advised everyone that if they wanted to be certain that they could participate in the entire meeting, they should come to Albany. Certainly, we apologize. It's not my doing, but we warned everyone this would happen, and it's happened.
So the one request, we would make here in New York is that which is public, obviously, will be public, and we'll see the minutes of what happened after we left. But the executive session won't be in the minutes, I take it. Could somebody in Albany take it upon themselves to give us a summary of what happens in executive session for those of us who are forced to leave now?
Let me just check and see if I'm allowed to do that. I just want, Peter, I'm happy to call you and Marvin and fill you in on what happens in executive session if I'm legally allowed to do it. So I will have someone research that issue as soon as the meeting's done. And if I can, I'll call you before the day is out and fill you in on what happened.
Okay, the alternative is, even though it's not a teleconference, Marvin and I could jump back in by phone for the executive session. We're happy to do that. If you just set up a call-in number there, then we can at least listen to it and participate verbally.
Yeah, I guess I think there's an issue with whether or not you can participate. You can't vote, but we shouldn't be voting in executive session anyhow. But I think that we can at least set up a call-in so that you can hear what happens in executive session. So let me have staff work on that. And where do you want us to send you the call-in number?
You can just email Marvin and me the call-in number and about what time that will be, and then we can do it.
Okay. I believe the only issue we have before we get to executive session are the lab disclosures, but there are quite a few of them. So I'll have someone send you an email with that information. And again, my apologies. This was beyond our control, but we did notify everyone as soon as we were notified this would happen. We were told there was no other facility at 633 available for us with video conferencing. So it's something that was out of our control. And I think this just points out, I understand everyone has busy schedules, but if people want to be certain that they're here and can participate in the full meeting, we do move the meetings back and forth between Albany and New York. There's obviously some advantage to being at the meeting in person.
Mike, do you have an estimate about when you think you'll move into executive session? A half hour, an hour?
I think that at a minimum, I would think that at a minimum it would take us a half hour to get through the lab disclosures. I don't see it happening before then. So if it does go faster than that, I will hold the executive session. I've got about 10 after 11 right now. So we won't start it before 11:40.
Thanks.
No, thank you, and my apologies. All right. Does anyone have any questions for Monroe County based on this issue? I recognize some of those people. It's you, Bill.
Oh, that's strike three.
Thank you. Appreciate you being here today.
Thank you.
Thanks, Jim.
Thank you.
Right. The next issue relates to Nassau County Division of Forensic Services. It relates to some email correspondence from July 13th and 14th of this year. Do we have anyone from Nassau County here?
I think if anyone has questions, what I've done is the director is at the other location, but I have his cell phone number. So if you review the documents, and I think for a number of these that involve New York City personnel, if you have questions, if you want to review the information that's in your binder, we can call them. And I've made, because of this awkward circumstance, we've made arrangements to have them available via their cell phone.
And just to summarize, if I understand it correctly, this has to do with a missed latent print identification. The nonconformance was originally reported to us, I believe, in January of this year. And they're indicating that the review was completed and that there was 82 cases reviewed and that there was no further issues that they identified. Is that roughly accurate?
Yeah, and ASCLED has reviewed the documents and closed the corrective action. So we received the notification. This was been before the commission already. Dr. Bufflin has come in and explained it and went through the entire process. So it's gone through, and because we get all the correspondence from ASCLED Lab, this is notification of closing that.
All right. And does anyone have questions or want to speak to representatives from Nassau County Lab? All right, no one's indicating, so we'll move on. Next issue we have is this one also the Nassau County Lab with regard to biology. It has to do with negative sex offense evidence kit and basically testing and then that was positive upon reanalysis.
If you want, I can explain that more. Just apologize for stepping. But what happened is the laboratories in New York have instigated maybe the wrong word, instituted a lab reanalysis program for a certain percentage of cases are reanalyzed. So in this particular case, there was a pair of underwear from a victim. It was a highly reflective surface. They reanalyzed that. Upon reanalysis, the subsequent analyst and a different analyst noted a stain that showed fluorescence under normal light. They then resampled that area and found it to be positive for the presence of semen. So they're evaluating it. They're going through a corrective action process, but just preliminarily, it was not something that was obvious right in the middle. It was a very small stain that was hidden off to the side, and they've taken the analyst off casework and they're going through.
Are they going to give us an update in December?
yes, there'll be a following update on that.
All right. Does anyone have questions for this or want to speak to someone from Nassau County Lab on this issue at this time? All right, the next issue is New York City. Right?
Oh, no, sorry, you're right.
Yeah, New York City OCME Forensic Biology. And again, if you want to just outline the issue briefly.
So this is over here. This is another closeout that has actually happened before. ASPAD Lab has a new investigator that's looking into these things. So this particular person has gone through a previous corrective action that was already reported to and pretty much closed out from the Commission on Forensic Science. This is now ASPAD looking at it, saying we've received all the documentation, and we also feel that this is appropriate and done, and closing it out. And this has to do with an incident from 2013.
Anyone have any questions from OCME with regard to this issue? Is the next one also OCME?
Yeah, it's the forensic statistical tool. So they had a corrective action regarding their forensic statistical tool. So the documentation's in your binder. If anyone has questions, I have a telephone number, and actually they just gave me another number they can be reached at if there's any questions about that.
Does anyone have any questions? All right, the next is also OCME, but the Forensic Toxicology Lab. Again, do you want to give us a brief overview?
Sure. They have several that have come up and been reported to the Commission. First had to do with pentobarbital, which is a barbiturate, and missing it in a particular sample. They also have one with benzodiazepines and methadone. There are different levels of corrective action that have gone through, that they're going through. So they've instituted procedures to start looking at that, and they're kind of trying to identify where the factors are that are causing it. With the benzodiazepines and methadone, that was one that was previously reported to it. They had done a root cause and kind of come up with some ideas of what it is in that documentation nearby.
With regard to both of those, is it fair to say that they have not completed the review, that they're in the process of doing the review?
Yeah, I believe they're at the almost end of it, but I think there's a little bit more documentation to look at coming up.
All right, will you ask them to give us what hopefully would be a final update on those two at our next meeting?
Sure.
All right, does anyone have any other questions for them? All right, next one's the New York City Police Department Lab. Again, can you give us an update there?
Sure. So we heard that they were looking at uncertainty in firearms, and that caused them to look at uncertainty in drugs. They found one issue there. It turned out to be a one-off. So at this point, they're essentially closing out the review of that. So there's also there about, this is the documentation that kind of supports that. So when you're going through, there's also, they have a different nonconformance, which it's just a typo on a report where one person put cocaine instead of heroin, that the report actually went out. So those two things are there. So the first is closing out a corrective action regarding uncertainty, and they've reported that numerous times to the Commission before. And the second one is actually just a typo that was on a report that led to something where they had to issue a new report.
With regard to the firearms one, if I'm reading this right, ASCLAD Lab has issued a statement saying that they've closed this out, found the action sufficient.
Yes.
All right, and with regard to the second one, ASCLAD has asked for a further status report, and that's pending.
Yes. And what they're doing, and I think it's good business practice, they've ASCLAD Lab, the accreditation provider, that one of the accreditation providers we're using now, is when any corrective actions are reported to them, they assign an investigator, and that person has a schedule of when they need certain things by, so nothing falls between the cracks. So you'll see this more on a lot of other things that are coming out. It's not that the corrective action or nonconformance is raised to a higher level that's causing them to be panicking. It's just this is a better business practice to always keep track of things, make sure things don't fall through the cracks.
And with regard to the controlled substance one, will you ask the New York City Police Department Lab to give us an update at the next meeting?
Yes.
Right. Any other questions or any questions for the New York City Police Department Lab? Next is New York State Police.
So there's several here. Again, just like before, we see some that are closeouts of ones from before as they're coming through, and others where they're asking for updates. So there's one that has to do with delayed DNA matches. That's been before the Commission a number of times, and ASCLAD Lab is essentially closing that out. There's another that has to do with missing profiles from the searchable index. Essentially, there's a little bit more work on the corrective action that's being looked at, and that information is being reported back to ASCLAD Lab, and they're looking for an update before the next Commission meeting. There's another issue that has to do with a contamination issue that was detected within toxicology. And the last issue has to do with firearms. There is a FOIL requests they received specifically for some NIBIN images, and upon going back to those cases, they found that the images weren't present. That caused them to look at the case a little more and found some other issues, which they addressed. You have the documentation in here. At this point, they're considering it closed. The examiner has since retired, and they haven't found any evidence of that issue anywhere else. And again, the documentation is within your binders.
I know we have the lab director here from the State Police Lab and others. Does anyone have any questions?
Could I go back to another issue just real quick? You know that thing that we had from the New York City Chief Medical Examiner about the profile being one allele or one loci off?
Yes.
Yeah. I just had a couple real quick questions about that. Remember years ago, Mike, it might have preceded your time here, but maybe Ann would remember. We were talking about familial searching. Remember that, Ann? And we argued about that. We finally came up with it. If you, Kathy, if you put in a profile into CODIS and it was one allele or one loci off, wouldn't it spit something out?
Well, currently the way the database is searched is they actually do at least a one mismatch search. So they do that on purpose. So that if a lab did accidentally make a mistake, they actually check it to see if you're allowed one locus where there could be a mistake, basically.
Okay.
And they might even do, and maybe Ray, maybe I don't know if you want to speak to that. You might even do a two mismatch search. I can't honestly remember, but they definitely do a one locus mismatch search.
Because what we did, rather than confronting it, I wanted to confront it head on and say allow familial searching. But I think Denise was the chairperson at the time. What we said is if the CODIS just spits something out, that we could use that as an investigative lead. And I know there was a lot of discussion about that. So if you're off by two loci, you would get a.
Well, so I think there's just two different issues. What you're talking about with the partial match is just based on the search algorithm and the stringency that it allows. Mm-hmm. So that they don't have to be exact, but they can have one allele or something that's similar. A separate issue is that it used to be that if there was one locus that was completely off, didn't have any alleles that were similar, that wouldn't have come up in a partial, although it could in a mismatch. So I don't know how to say. They're basically two different issues. The partial match issue is a stringency issue, and this issue is basically having a wrong allele typed in there.
And the other question I had, Brian, is I noticed in a couple of the cases they say the named offender's DNA profile was typed in the Virginia State database. Why?
I think that's where the hit occurred. It occurred to a national offender, so it can either hit within the state or through the national.
Oh, okay, because they mentioned that more than once, so that's just a coincidence that there were two guys from. Okay, sorry about that.
Someone's reading the material, right?
That was the real purpose of my question.
Anyone from the State Police Lab have anything to add with regard to the state police disclosures? Or does anyone have any questions for the lab?
I just had a question. I'm sorry, I just was looking at this last night. I think it's on the tox corrective action that you submitted.
Maybe I can ask you just to come up to the table so that we make sure that everything gets recorded here.
Hi, for the record, I'm Ray Wickenheiser. I'm the director of the New York State Police Crime Lab System.
Hi.
You had a question.
Sorry. I just had a question. I just want to make sure I understand it. So you had an ELISA screen that was positive. The confirmation was positive. The confirmation was repeated, and the results matched. But because the screening test was also repeated, and the results did not match, so you're reporting that out as a negative because you wouldn't have normally put it through confirmation if the screening was negative.
Correct. As part of our investigation into this quality event, we did a number of measures, and one was to look at the ELISA. And inadvertently, a sample had gone through. There was a very low level of opiate in the sample. But it would never have gone through because the screening was negative. So given that, and we wrestled with this because it seems a little counterintuitive, but given that our procedures are such that if our screening is negative, we were then to stop and issue a negative report. So given that, we provided full disclosure, and we reissued a report adding that language of this unique circumstance and making a determination that, given our procedures were such that screening was negative, should have never gone through to confirmation. It was, again, a low-level sample.
It was a low, that was kind of my question,
Right.
so it was a low-level sample, that makes sense. Okay, thank you.
Thank you.
All right, anything else?
There's one other corrective action that just on the state police end, and again, I don't necessarily know that there's any questions, but one of the regional laboratories that was doing drug testing just had an issue where some samples that were being shipped to the customer didn't end up there. So,
Right, just to clarify, that was actually here in Albany.
okay, sorry. So one of the big lab, so to speak. So either way, the mechanism. So they're looking into it anytime that there's a sample that doesn't go where it's supposed to go. They're looking into it. So the documentation's in your binders if you have questions on
What's
that.
the status of that now?
That's an initial notification. We've done considerable follow-up, but at this point, the original correspondence was just to notify of the issue. There are some drugs missing. There is a slight gap in terms of the video where somebody was shown putting the items in the box, but then went around the corner out of video to weigh the box, then came back. So we just can't close the gap on our own staff, albeit we have no belief that there's any wrongdoing. We just now changed our procedures that everything is done under camera, and we're investigating to see if there's UPS or any other issues where they're
Will we get an update on this?
we will absolutely. This is just an initial notification. We'll provide updates as we go through our full investigation.
All right, thank you. Anything else? Thank you.
Thank you.
Next lab is the Niagara County Sheriff's Department Laboratory, and they're available if you need via cell phone number. If that's on you there.
No?
It's basically they have a situation in toxicology where there's a sample switch. So if you need, they're available via telephone to talk about that. It had to do with I believe a breath alcohol, a blood alcohol case. Any thoughts or questions there? Next one down is the Suffolk County, and I believe it might be the last one. Let's see, I just got it by, yeah. So,
We have three from them.
yeah, so we have, from Suffolk County, there's three different ones. There's, again, a drug weight discrepancy. There's issues with how something was documented on a crime scene photo log. There was a sample switch within the fire debris section. So those are the three that are there, and you have documents within your binder. If anyone has any questions, the members of the laboratory are available via telephone.
Are all of these issues that they're in the process of doing follow-up or investigating?
Yeah, so at this point, for the first one with the drug weight discrepancy, it's already been reported to ASCRIBE Lab. They're looking for a status back before the end of the year. Same thing with the photo log discrepancy. And also, I believe, let's check with the last one. Yeah, there's another update that's going to be required when things are reviewed. So we'll get an update on all three of these at the next commission meeting on December 18th.
All right. Anyone else have any questions with regard to those? No, thank you. All right, so all we have left is executive session. I promised them we wouldn't start for another 10 minutes, so why don't we take a 10-minute break? And then when we come back, we'll go into executive session. So why don't we do this? Before we break, do I have a motion to go into executive session to discuss matters relating to either a current investigation or matters that may lead to the appointment, promotion, demotion, discipline, or suspension of a particular person? I have a motion, I have a second. All in favor? Thank you. All right, so we'll come back in 10 minutes in executive session. We did have an executive session. We did not take any votes or any other action that would need to be on the record during executive session. Our next meeting is December 18th in New York City. With that, I think we've completed our agenda. Do we have a motion to adjourn? Do we have a second? All right. Anyone opposed? All right. Thank you very much. Appreciate everyone's time.